Understanding indemnification clauses can save independent contractors from significant financial and legal headaches. These powerful contract provisions determine who bears the risk when things go wrong, making them essential to master before signing any agreement. Indemnification is fundamentally about transferring risk between parties in a contract. When an indemnification clause appears in your contract, it ensures that potential losses will be compensated. If you're the party covered by this clause, the other party is promising to compensate you if their actions cause you to suffer a loss, such as being sued by a third party. The phrase defend, hold harmless, and indemnify forms the backbone of these clauses. While hold harmless and indemnify essentially mean the same thing, covering losses that you have caused, the word defend carries special significance. If included, it means the party that caused harm must defend the indemnified party from lawsuits. Many parties prefer to omit this word to retain control over their own defense. Indemnification clauses come in three main forms, each determining how much liability a party assumes. Broad form indemnity is the most extensive, where the indemnifying party assumes all liabilities, even for claims resulting from the other party's negligence. This form is controversial and sometimes unenforceable. Intermediate form indemnity makes the indemnifying party responsible for their own negligence and partial negligence of the other party, but not if the other party is solely responsible. Limited form indemnity is the most restricted, covering only liabilities resulting from the indemnifying party's own actions. For independent contractors, mutual indemnification clauses are particularly valuable. These clauses ensure both the client and contractor take responsibility for risks within their control. A well-crafted mutual indemnification clause protects each party from damages caused by the other's actions, creating a balanced approach to risk management. Key elements of a mutual indemnification clause include the scope of indemnity, which defines what damages and claims each party covers, provisions for legal fees and defense costs, specific exclusions where indemnification doesn't apply, and time limits for making claims. Consider a practical example. A consultant working with a company might include a clause stating that the company indemnifies the contractor if claims arise from the company's internal policies, while the contractor indemnifies the company for damages caused by professional negligence or contractual breaches. When negotiating an indemnification clause, several factors require careful consideration. First, clearly identify which party bears the risk for different types of claims. Second, verify whether your professional liability insurance covers your indemnity obligations. Independent contractors should ensure they have adequate business liability insurance to cover potential claims. Limiting liability is another crucial aspect of negotiation. Try to establish caps on damages to avoid unlimited financial responsibility and specify exactly which types of losses are covered. Be aware that state laws may restrict how much indemnification one party can demand, and certain industries like construction and technology often have stricter requirements. If you're reviewing a contract with an indemnification clause, read it thoroughly to understand the language. Pay attention to whether you're required to defend against all claims or just reasonable ones. If you're not the indemnified party, push for a cap on the losses you'll be required to cover. If the other party requests a higher cap, negotiate for a higher price in exchange. For software developers or other professionals guaranteeing non-infringement of intellectual property rights, limit your warranty to known IP rights rather than all possible rights. Consider investing in professional indemnity insurance to cover damages and legal costs if you breach a contract. The most important advice for handling indemnification clauses is to consult an attorney before signing any contract. These clauses can have significant financial implications, and professional legal guidance ensures you understand your obligations and protections. Indemnification clauses serve as a critical risk management tool in independent contractor relationships. When properly structured as mutual agreements, they create a fair balance of responsibility that protects both parties from liabilities resulting from the other's actions. Taking time to understand, negotiate, and customize these provisions with professional legal assistance will help ensure your business relationships remain both protected and productive.